Hi there. In this video we're going to talk about unfair dismissal. What is unfair dismissal? How you can go about making a claim for unfair dismissal to get compensation, and also some of the typical defences that you can encounter, and other matters such as how much you should get and how to conclude a settlement agreement for unfair dismissal. My name's Alex Monaco, solicitor and owner of Monaco Solicitors, specialist solicitors for employees only. So, what is unfair dismissal? Well, as you might have gathered, it is when you are unfairly dismissed from your job. You do need to be an employee rather than self-employed for this. And unfair dismissal rights come from Section 98 of the Employment Rights Act 1996. Now that act says that you need to have been employed for 2 years, so you need 2 years continuous service in order to claim unfair dismissal. If you've been there for less than 2 years, then sadly you can't claim for unfair dismissal. What you can still claim for are things like discrimination or whistleblowing or health and safety related claims. You can check out all those types of claims and the videos for them on our website at monacosolicitors.co.uk. So if you've been there for more than 2 years and you don't have one of those discriminatory or other types of claim, but you were simply dismissed for reasons, other than those reasons, then you need to look at as well your time limits. You need to be aware of your time limit, which is 3 months. You have 3 months to make a claim for unfair dismissal or to notify ACAS about your unfair dismissal claim. So after 3 months have passed, if you haven't done anything officially about that, then sadly you're out of time and you won't be able to make a claim or proceed with a settlement agreement negotiation. So make sure whatever happens and whatever your employer says to you in terms of a negotiation, don't let them string you along until 3 months have passed. By the way, let's just make a delineation between unfair dismissal and other types of dismissal like constructive dismissal or wrongful dismissal. So constructive dismissal is where you have resigned or where you're still in your job, you're being forced out. It's a kind of unfair dismissal, but the difference is with unfair dismissal, you've actually been dismissed by your employer. Most often they'll put that in writing, but it can be verbal. So if you've left, it's unfair dismissal. If you haven't left or if you resigned yourself, it's constructive dismissal. Then there's wrongful dismissal, which is a different kettle of fish altogether. That's where you haven't been paid your notice period in your contract. So if you have a month's notice and you're just let go of and not paid that month's money, that would be wrongful dismissal. That's different. So why could an employer dismiss an employee fairly? Let's look at it that way round. By and large, there are 2 reasons why your employer can dismiss you fairly, in quotes fairly, because we know employers often do things unfairly even when they officially are doing things by the book. So those 2 things are conduct and capability. If it relates to your conduct and the things that you did, for example, extreme example would be punching the boss or having your fingers in the till, then that's a legitimate reason for being dismissed. Or it might relate to capability, so your performance, how well you're doing in your role, whether you're hitting targets. These are legitimate things that employers are allowed to dismiss employees for, and it can often be very difficult to prove otherwise. So depending on what evidence you've got, and it's all about evidence, whether you're going to fight a tribunal case or whether you're going to negotiate an out-of-court settlement, the more evidence you have, the better your chance of success is. Evidence for unfair dismissal cases might include email evidence. You might have, for example, emails from your boss to other people saying, oh, let's get rid of this person because we don't like them, or perhaps their face doesn't fit, or some other reason, that some unfair seeming reason. There are many reasons why people are dismissed unfairly. Other types of evidence include witness evidence. Perhaps some of your colleagues know what went on and they can back you up. This is harder to get because they're obviously going to be concerned about keeping their job, so they might not want to be a witness against their old employer. And then there are other types of evidence, for example, recordings of meetings. You can record meetings that you go to with audio devices, perhaps with your phone. We don't necessarily recommend you do that, but on the other hand, judges will look at that kind of evidence if the impact of that outweighs the adverse effect that it has on the employer. You can read more about evidence on our website on the evidence guide, and there's a video on that too. So what kind of compensation should you be getting for your unfair dismissal claim? Well, after tribunal, you can get a maximum of 1 year's salary if you win. Tribunals are difficult to win and they do take a long time to progress. We do represent clients at tribunal at Monaco Solicitors, so do ask us about that. Our first port of call, however, would be a settlement agreement negotiation. So we would get in touch with your employer off the record, perhaps pick up the phone, perhaps write a nice without prejudice letter, which you can again read about on our site, and try to settle the case off the record in a confidential way. Often in a typical case, we might start by asking for, first of all, your notice pay, paid in lieu. So in other words, you don't have to work, but they pay your notice pay, and then some financial compensation to reflect the money you will have lost between your unfair dismissal and your new job. So that is the compensatory element of an unfair dismissal claim or a negotiation. How long are you going to be out of a job for? Most people are out of a job for perhaps 3 months, maybe 6 months at the top end if you have a specialist role. It's very unusual to see more than that unless you're a very specialist role, perhaps a very highly paid person with only a small handful of companies that you could apply for. But anywhere between the 3 to 6 months mark plus your notice period is generally what you should be aiming for. As I mentioned, if you do use a solicitor, they will be adept, hopefully, if they're specialists, at pursuing out of court settlements. Otherwise, if you're going to do it yourself, have a go at some of our letter builder tools on our website, the award-winning virtual lawyer tool, for example. You can perhaps write your own letter and see if you can negotiate something. It does help if you put it in writing and write the words without prejudice at the top of that letter. That's going to make your negotiation seem a lot more formal. Other than that, if you do go to tribunal, you do need to be prepared for quite a long process. We would recommend that you instruct solicitors to at least draft the ET1, which is the document that originates the tribunal claim, just to make sure you've got your bases covered. From there, if you want to go ahead and represent yourself, you can do that a bit more easily because you've got that foundation of a professionally drafted ET1 document. So in order to read more about unfair dismissal or other types of employment law claim and negotiation, just check out some of the other videos that we have on our website and or on our YouTube channel. Don't forget, if you're on YouTube, give us a like and subscribe to the channel. And if you want to speak to us about possibly getting a free consultation, please do get in touch. It doesn't cost anything to ask. Thank you very much. Goodbye.